Hello and welcome everyone to my discussion on reasonable skill and care. I'm going to speak today on this important topic, which is very critical for construction professionals for understanding this liability. Common issue of disputes between parties who have entered into a design and build contract, wherein the design part and the build part of the contract give rise to different obligations. Contractor in particular is unaware of this and incorrectly presume that these obligations have the same consequences and are freely interchangeable. The contractor finds himself in complex situations when it comes to liability. The two obligations in question are as follows. The contractor's design part is to be carried out with reasonable skill and care. That is a duty to exercise the level of skill and care expected of another reasonable competent person of the same profession, called a process obligation. The contractor's bill part is to be carried out so that the end product is fit for its intended purpose. That is, the contractor must achieve a particular performance result called a result obligation. This distinction between design and build was provided in the case of Hogarth and Eon by the English Court and Scottish case of SSE Generation Limited. As a contractor, when considering a contract, the contractor must be clear on where liability for design and liability for workmanship begins and ends. A fit for purpose obligation effectively warrants a particular performance for the life of the structure built, which, which is much more wondrous than a simple reasonable skill and care obligation, and should therefore be avoided if possible. It is important to note that many insurers do not provide cover for a fit for purpose obligation. Therefore, it is important that the contractor should know and understand the contract, ensure the insurance covers the specified obligations. Definition under common law of English and Wales. The accepted standard of reasonable skill and care is the standard of an ordinary man who exercises and professes to have that skill. This definition was given in the case of Bolam and Frank. Reasonable skill and care is the level of skill and care appropriate to the experience that the party holds itself out of possesses. This definition was given in Chaudhary versus Prabhakar. When a party professes to have a greater than ordinary degree of skill, greater than it actually has, the level of reasonable skill and care to be expected of him would be judged on the level that person professed to have, not the lesser level of an ordinary person in that field, as defined in Wimpey Construction, UK. Definition: International construction perspective. A reasonable skill and care should be of that level which can be expected from an international contractor to exercise in the performance of its obligations and duties, taking into account the usual applicable standards prevalent specifically in the construction industry. The level of reasonable skill and care applicable to a designer will include a duty to amend his design if it appeared deficient during the construction. This was confirmed in the case of London Bureau of Merton versus Louis. By adopting the principle of reasonable skill and care means that a party should do its best without guaranteeing success, as opposed to fitness for purpose, Fitness for purpose imposes upon the contractor a strict obligation to succeed. Failure to succeed will lead to contractor's liability for the consequences of its failures. Reasonable skill and care under civil courts. Under the common law of England and Wales, the reasonable skill and care obligations is an implied term. However, in civil law, that is civil courts, the reasonable skill and care should be expressed in terms of rule. The French Civil Code has two contradictory rules. These rules are as follows. Under Article 1137, an obligation to, to watch over the preservation of a thing compels the one who is responsible to give it all the care of a prudent administrator. Under Article 1147, a debtor will be ordered to pay damages unless there is an event of non-performance of obligation or delay in performing and the person proves that the non-performance and delay arose due to an external cause which may not be attributed to him and, and there is no bad faith on his part. Contract situations. There are two types of contract situations. First type, under Article 1137 as referred above, the debtor has an obligation to take the measures that a reasonable person should take to achieve the intent of the contract and is therefore bound no more than the exercise of reasonable skill and care, which is covered under Article 1137. This is called an obligation de moines. Second type. In the second type, contract situation covered under Article 1147. The debtor's obligation is not only to show due diligence but also to achieve the result which it has promised. This is called an obligation de resultant. To escape the obligation in this situation, the debtor must show that its failure to produce the promised results is due to an external cause beyond its control. Difference in the two types of obligations. The difference between the two types of obligations relates to the level of burden of proof. Under obligation de moines, the burden of proof will be on the creditor, whereas in the obligation de resultate, the creditor has to prove that the result is not achieved, then the burden of proof will be on the debtor to show a cause étranger. Article 1137 makes liability dependent on proof of fault and Article 1147 makes exemption from liability depend upon cause of étranger. For instance, a sports team captain has not promised success and so he would be an obligation de moines, while a flight has a definite starting point and a definite arrival point, and so the airline on which a person is on board would have an obligation de resultate which can argue that diversion was forced due to strong winds that would be classed as a cause stranger which was beyond the control of the airline. German Civil Code. Under the German Civil Code, Article 276, the obligator is liable for deliberate and negligent act of omission, unless the existence of a stricter or more lenient degree of liability is specified or to be inferred from the other subject matter of the obligation, in particular the assumption of a guarantee or the acquisition risk. A person acts negligently if he fails to observe the relevant accepted standards of care. The obligator cannot be relieved in advance of liability for deliberate acts or omissions. German Civil Code Article 277 states that a person who is liable only for failure to display the standard of care that he displays in his own affairs is not relieved of liability for gross negligence. Conclusion. From the above discussion, it can be assessed that under the codified system of jurisdictions, civil codes, in particular the French civil code, is clear and precise than under common law systems. However, the basic principles are the same. Thank you.